We have some potential home buyers asking why they need to sign a buyer-broker agreement and what is it. So here's a quick video that explains what a buyer-broker agreement is, what terms you can put on there to limit your agreement with an unknown agent if you don't feel comfortable with the agent yet, as well as other important information that you will need to know and should know when you're ready to work with an agent. So take a little bit of time and review the video, and if you have any questions, give us a call. You are required by Virginia law to have agency disclosure in writing and signed. Hi, my name is Ida Walsh, and in this video we will review the standard NBAR buyer-broker agreement so that you know what you're signing, understand the terms of the agreement, and the importance of agency relationship and associated duties, as well as other disclosures and addendums. Our goal at Your New Home Team is always to educate, inform, and empower our clients. Through utilization of videos, checklists, websites, ebooks, guides, webinars, and downloads, we aim to provide information in multiple channels, making it super convenient for our clients. Buying a home or an investment property is a significant investment, both for you and your family, if you have one. Transactions can get complex, especially in today's real estate market. So finding an agent that keeps up with the changes in contracts and the market, and one that will guide you through the process that you can communicate with, is an important decision. Make sure you understand all the paperwork and contracts that will legally bind you. Sometimes one word can make a huge difference in a contract and the offer terms. Our goal in this video is to effectively explain all terms. So let's get started with the agreement form. This buyer-broker agreement is between the buyers, you, and the broker agent. There are two primary types of relationships that exist between real estate agents and the buyers. There is the seller's agent and the buyer's agent. The seller's agent represents the seller and owes fiduciary duties to the seller only, and the buyer agent is on the opposite side, owes the fiduciary duties to the buyers only. Now, prior to 1992, all agents actually all worked for the seller, but buyers wanted their own representation without cost. So that's when the buyer-broker representation was brought about. Effective July 1st, 2012, Virginia law requires that this agreement be in writing to protect the consumer that you have representation. This is your right under the law. Signing up buyer-broker agreement is the law, but seeking the best representation possible for your specific needs and wants is extremely important. It means that both parties are committed to working together to establish an intended purpose. Buyer-broker agreement is a contract similar to an employment contract. It basically establishes a business relationship between you, the buyer, and the agent. The agreement must include the start and end date, what and how the broker will be paid, and then the duties and the obligations of all parties. Unlike other jobs, real estate agents only get paid when there's a successful transaction. So all expenses are incurred by the agent before the potential of a home sale is evident. They need to have the necessary skills to complete a successful transaction. So think if you were offered a job that was only dependent upon successful completion. That's what we work for every day. Article 1. As you'll see, the exclusive right to represent purchaser agreement is made on a specific date, and that's the start date, by the client names, all the purchasers that will be participating in the purchase of the home, and then the brokerage name. Now, this is not your agent's name, but the brokerage name. The Article 1 is basically the agreement that grants the right for the broker agent to represent you in the purchase of the real property. Now, this may include a home, land, or a commercial property. It's basically a permission to do limited activity on your behalf. Before we get started, let's just quickly review the differences between brokers and broker agents, or the buyer agents. In this case, you'll be working with a buyer agent. There are many different brokerages, and most of these brokerages are independently owned by brokers who hire basically sales agents or reps. Each of these sales agents are independent contractors working for commission while performing under the guidelines of the broker. There are lots of agents, and finding the right agent requires a little bit of research. Each agent offers unique and specific experience, knowledge and background in different areas, and then the work availability. Some people are full-time, some people are part-time, and some people have specialty skills. And of course, the most important part is really the communication skill. You really need to find somebody that you can really communicate with. Article 2 in the agreement points out the need to discuss previously visited properties. Now, this is important to remove any conflicts with any other agent or a builder claiming procuring cause, and to determine if you're still interested in the properties that you've already seen with others. Procuring cause is a term used in real estate when it comes to understanding who actually did the work for the buyer to find the property. So here we need to know if you've seen any homes with other agents, or if you've seen or signed in with any builders or model homes, and if you've registered with them at all, and if you have any interest in going back and purchasing those homes. Article 3 is simply exchanging of contact information between the client and the agent. Now, this information is used to handle all communication between the parties. Article 4 basically defines the term of the agreement. This indicated the expiration date of the agreement. This expiration date may be for 1 day, or for a specific property, or for a period of time. It's up to the parties to decide how long they wish to work with each other. Now, some buyers may not be comfortable signing an extended period for the agreement for a number of reasons. Perhaps you're not sure that you're a committed buyer at this time, or that you just met the agent, or you want additional time to discover if the agent is really the right agent for you. Or maybe the agent was referred to you and you feel confident of their abilities and skills and experience to represent you. Once you've spent sufficient time with your agent and you feel confident that they'll be able to effectively represent you with your home purchase, then you can put the terms, the expiration date here. Article 5 refers to the retainer fee. This is much like an attorney charging the retainer fee for prep work ahead of time, and offers compensation if the buyer chooses not to move forward for the work done. So we see this type of fee as compensation in a small way of time and expense if the transaction does not proceed under the agreement. Now, the specifics of the retainer fees can be discussed case-by-case basis with your agent. And retainer fees are usually received for specific fees or additional costs that may be incurred on behalf of the buyer, and some of these may be subtracted from the earned commission at settlement. In Article 6, broker duties are outlined, but there is far more depth to them than what's explained here, so it's really important to review these duties for better understanding and how they will apply in your specific situation. In broker duties, your interest is to be promoted at all times, but we cannot be dishonest to any party. We seek a property at a price and terms acceptable to you, and this is where the listening skills are crucial in understanding what you must have versus what you would like to have. Next is presenting your offer, the counter offers, in a timely manner. This is where technology can come in, getting documents back and forth quickly, utilization of digital signatures, and others. Not following instructions can affect whether your offer gets accepted or not. Disclosing to the purchaser all material facts. Now, you'd be surprised by how much we're told by the seller or their agent. You really want someone who can relay this information to you, and to do so, they need to be your agent. Accounting for in a timely manner all money involved. The Virginia law requires proper handling of money. Unless otherwise provided by law, or purchaser can send in writing to release information, some financial information must be disclosed so the listing agent can determine if this contract can come into fruition. For additional information to be released, we need your permission to do so. Broker and agent shall maintain confidentiality of all personal and financial information that you have not given permission for us to release. This is particularly important, especially in certain circumstances, whether buying or selling a property, and remains confidential even after the settlement. When a contract is prepared, it needs to represent a true picture of your purchase, not your personal details. In addition, we're allowed to show the same property to other purchasers, represent other purchasers in the same or other properties. We can also provide assistance to a seller or a prospective seller by performing ministerial duties that are acts that help move a transaction along but have no representation involved, such as assisting a for sale by owner or handling paperwork for different activities that one would need without representation. Article 7 outlines the purchaser's duties. Basically, it states purchaser shall work exclusively with the broker during the term of this agreement, pay the broker directly or indirectly the compensation set forth, and comply with the reasonable requests of broker to supply any pertinent financial or personal data needed to fulfill the terms of this agreement, and also be available during broker's regular working hours to view properties. Now that you're in the buyer mode, you'll be anxious to visit homes, but go with your agent. Visiting a new home site or open houses without your agent may be a disadvantage for you. Builders often require registration in exchange for information, but you may also want your agent to be there at the same time. Now, if you decide to take a Sunday drive and visit open homes or open model homes, indicate immediately that you have an agent that represents your interests. Never fill out anything unless you have specifically outlined that you have an agent and who they are. But it's usually best to make arrangements ahead of time. So let your agents know if you plan on visiting any model homes so that he or she can call ahead of time and register you as his or her agents. Now, not having your agent there can take away from negotiation abilities. Viewing properties with multiple schedules can be difficult. Flexibility and synchronization of time slots may become crucial and should be discussed up front between the client and your agent. Schedules change and vary. When a great opportunity comes on the market, it may be crucial to drop everything and go if the need is there. So discuss these terms with your agent. Article 8 outlines the purpose of this agreement and asks to complete the type of property or properties that you're interested in purchasing. Article 9 is compensation. As we discussed earlier, a buyer-broker agreement is an employment contract of sorts, a service for pay. In most cases, seller pays all commission as part of the sales price. This agreement allows for that process to continue. Section B of this contract states that after so many days, and we usually put about 30 days in here, after expiration, if the purchaser goes back and purchases the home that we've shown them, then the agent will still be compensated as they were the procuring cause. Section C basically states that the broker is still entitled to their commission if everything was done and the purchaser defaults on the contract. The broker fee percentage and any other brokerage fees will be included in the line outlined. Article 10 talks about relocation, and if you're relocating to and from, and if you're using a relocation company. The information on the relocation company must be entered here so the coordination can take place. Article 11 talks about different types of real estate representation. As we discussed, there are seller representation and buyer representation. Now, the seller representation basically owns fiduciary duties to the seller. An example of this would be basically an open house where the listing agent is representing the sellers, or a builder with homes for sale and the listing agent is representing the builder, or a sales rep that's representing the specific builder. At this point, the purchaser is without representation because the other agent is representing the sellers. On the other side, the buyer representation, and that's what we're discussing now, this is when the buyer has their own agent that's looking out for their best interest. Now, there are different types of buyer representation. That's what we're going to go over now. A designated representation happens when the buyer and the seller agents are under the same broker, but they still keep their own client information confidential and they work in the best interests of their clients, but they still work for the same brokerage. Dual agency is a situation in which there's only one agent representing both the buyer and the seller, trying to bring both parties together. This can be similar to having the same coach coaching two different teams and both come out winners and have the ability to get all the necessary attention one needs in purchasing or selling a home. Now, you're given a special form to sign when there's dual agency involved. In this case, the agent cannot make any recommendations or help you with any problem that may cause an advantage over the other party, or assist and counsel you and the best choice and or the safeguards. So this type of agency may not be for everyone. And dual agency basically boils down to having no agency. It's very hard to represent both parties and make both parties feel at an advantage. We often shy away from dual agency, except in certain circumstances where everything is disclosed and both buyer and the seller strictly agree on the terms and type of representation. Article 12 is a disclaimer. The disclaimer that basically states that we're experts in real estate and real estate only. So here it states that the purchaser acknowledges that the broker is being retained solely as a real estate agent and not as an attorney, a tax advisor, lender, appraiser, surveyor, structural engineer, mold or air quality expert, home inspector, or other professional service provider. The purchaser is advised to seek professional advice concerning the condition of the property or concerning legal and tax matters. The purchaser shall exercise whatever due diligence purchaser deems necessary with respect to information on sexual offenders registered under the Chapter 9 of 9.1, and we have the phone number and the website included here as well as information below. Article 13 talks about fair housing and the compliance with the fair housing laws. It basically states that our business is to service our clients and to sell real estate. That property shall be shown and made available without regard to race, religion, color, sex, handicap, familial status, or national origin, as well as all classes protected by the laws of the United States, the Commonwealth of Virginia, and the applicable local jurisdictions, or by the Realtor Code of Ethics. Article 14 basically outlines other provisions. Other provisions is basically anything that the purchaser and the broker agent would like to add to this contract. Now, this is a great place to add what the retainer fee is for or what it will cover, and other agreed upon negotiations. Article 15 is the miscellaneous. It basically states that this agreement, any exhibits and any addenda signed by the parties constitute the entire agreement between the parties and supersedes any other written or oral agreements between the parties. This agreement can only be modified in writing and when signed by both parties. The laws of Virginia shall govern the validity, interpretation, and the enforcement of this agreement. So remember, when there's any kind of modifications happening to a contract, you have to make sure that it's signed by all parties. Article 16 is about the penalties of not moving through with the agreement. It's called the breach of contract. And here it states that if one party breaches the contract while the other party is trying to still go through with the contract, then there could be a breach of contract, and the compensation and the damages will be enforceable. And you can read more in the details of this. And if you do have specific questions about this, then we do have legal counsel that you can definitely talk to about any part of this agreement, not just this part, but as far as the entire contract. If you have any specific questions, we can get detailed information for you from an attorney. The last part is the signatures, and this is where all the parties that are involved in the purchase of the home needs to sign, as well as the broker, and this is where your sales associate information will also be included. Now, you can do this via digital signatures, you can do it on your tablet, you can also do it on your phone. And if you have any questions, please feel free to give me a call or anybody in our office that can answer any of these questions. But before we end, we do have a few addendums. So some of the few addendums that we need to really look at and understand are Megan's Law, understanding the VA Residential Disclosure Act, the useful information about real estate transactions, the information concerning short sales and REO or bank-owned properties, and then the RESPA disclosures, the Realtor's Role from the Virginia Association of Realtors, and then there are some others that may be required, such as lead-based paint. One of these is the Megan's Law. Now, Megan's Law basically talks about sexual offenders. We provide the information here with the phone number and the website link so that you can go and do your own due diligence. We as agents are not allowed to provide any information or disclose any information if there are known sexual offenders that live in the area. And again, here is the website. And the Virginia Disclosure Act is actually really important. In Virginia, unlike some other states, the sellers do not really need to disclose anything. You're basically purchasing the home as is, and you're required to do your own due diligence. And we have an entire video that explains more about the Virginia Disclosure Act. So please take some time and actually watch and review that. RESPA is the Real Estate Settlement Procedures Act. It basically states that they need to disclose any relationship, fees, and partnership benefits that are part of any transaction. It prohibits kickbacks between lenders and third-party settlement service agents in the real estate settlement process. For example, a lender advertising a home loan might have advertised the loan with a 5% interest rate, but then when one applies for the loan, one is told that one must use the lender's affiliated title insurance company and pay $5,000 for the service, whereas the normal rate is $1,000. So the title company would then have paid $4,000 to the lender. This was made illegal. It basically states that there can't be any undisclosed kickbacks to each other or inflation of the cost of real estate transactions and obscuring the price competition by facilitating bait and switch tactics. There's also some documentation about short sales, and short sales can take a long time. You just don't know, and it's an oxymoron to say it's a short sale because it can take months, in some cases years, to hear back about an opportunity or a sale of a home. They are trying to improve that, and there has been a lot of different systems put in place to speed up the process of hearing back from the bank, but it still depends, especially if a home has 2 different loans on it or 3 different loans on it, and it needs to get approval from 2 or 3 different lenders. Foreclosure on bank-owned properties can be great opportunities. Often they're a good deal because the home really hasn't been maintained, the condition is unknown, and the bank is looking to move it off their books. It does come with some caveats. Now, if you manage to do your home inspection, which in itself is another challenge if the utilities have been turned off and the home hasn't been maintained. But let's say that you were able to do that and you find damage to the home that would need to be repaired. You would basically be on your own. Bank sells their properties as is, and they will usually, in most of the cases, they will not do any repairs to the home. Also, both the VA and FHA loans will require inspections and have their own guidelines on the approval process. So even though you may be okay with the home in a specific condition and think that you can fix things up, banks may not feel confident in approving the mortgage based on the required home improvements that may have to be made. Homes built before 1978 may contain lead-based paint, and these can be hazardous and they need to be discussed. Now, you'll need to understand the risks involved and how you can test for lead-based paint if desired, and you'll receive this brochure that will include all of that information. We hope this introduction to buyer-broker agreement was beneficial. If you do have questions, we do have legal counsel that you can discuss the terms of the agreement with, and we do have other recordings, such as the ones that we disclosed earlier. And we can also do a webinar and go through any questions or concerns that you may have so that you can get a full understanding of the contract that is specifically designed for you. If you have any questions, you can feel free to call me or call our office at 888-WALSH11.